Obviously, the arbitrator, they don't need any presentation. I think you all know them, but just a few words. The panel will be chaired by Miss Patricia Moyersoen. Patricia is the founder of the Moyersoen law firm. She's the president of IAF and one of the most experienced Haas counsel. Then we have Ulrich Haas, is the professor at the University of Zurich, president of the Basket Arbitral Tribunal, and one of the most experienced Haas arbitrator. And Jacques Radoux, referendar à la European Court of Justice, former captain of the of the Davis Cup team of Luxembourg, and one of the most experienced Haas arbitrator. It's a great privilege to have them here, and thanks a lot for accepting our invitation and appointment. I'll now ask the appellant and the respondent to take their seat and leave the floor to the panel. Thanks a lot.
Hello. Has seat in Madrid. I'm very happy to chair this panel. I'm also very impressed, not only because the location is just really great, fantastic, also because it's my first time, maybe like you, sitting as an arbitrator. Usually I sit as a lawyer, so I know how you feel. First time I was also to chair a Haas panel. I'm very happy to have my co-arbitrators, Ulrich Haas and Jacques Radoux, already presented. And I think we will have an hour, because it's very short, but we will deal with it. And I'm sure you will together deal with this time limit. So we know that maybe you can present yourselves as the oralist, who you are.
Good afternoon, panel. My name is Priyanka Jaiswal, and this is my co-counsel Rishav Kumar. We will be representing respondents, that is FIFA in the present case, and I will be dealing with the issue of succession, and my co-counsel will be dealing with the rest of the issues. Thank you.
Thank you. Can you present yourself?
Hello. Good afternoon. My name is Sebastian Plows, and this is my colleague Paul Gregori. We are from the University of Bergen. We'll be representing the appellant ETA SC 2020. And I also will begin with the issue of sporting succession, and my colleague will handle the remainder of them. Thank you.
Thank you very much. So first, I would like to ask both party if you have objection on the procedural order you received.
No, we have none. We confirm.
Can you repeat the question? Sorry.
Do you have objection on the procedural order?
No objections.
So I give the floor to the appellant. You have the floor, please. Just 1 minute. You have 20 minutes each, and we have 10 minutes for questions. We may interrupt you for questions during your pleadings, but of course, the time will be deducted, the time of the question of your 20 minutes. So altogether, you will have 30 minutes. So don't worry, the question will be short. Of course, hope the answers will be short too, but you will have the whole time, and you have to manage in this 20 plus 10 minutes.
Thank you. Dear Madam President and honourable members of the panel, as I said, my name is Sebastian Plows, and I will be addressing issue 1 for approximately 10 minutes. As we see it, the main issues to be resolved by the panel are, firstly, whether ETA SC 2020 is the sporting successor of ETA FC 1997. Secondly, if ETA SC's right to be heard was violated during the original DLC proceedings, and if so, whether it affects the challenge decision And thirdly, if Ms. Nikki can claim the debt before FIFA. This third issue is twofold, where the first question is if Ms. Nikki's acted diligently, and the second question is if the decision denying Ms. Nikki's claim is a case of res judicata. I will now turn to the first issue of sporting succession, bullet point 1 of our skeleton arguments. According to the FTC Article 15, subparagraph 4, a club may be held responsible for a former club's liabilities. This is called a sporting succession. The article states in a non-exhaustive manner the relevant criteria in the assessment of a sporting succession. However, and I now move on to issue 1.a of our skeleton, it has been held in cast jurisprudence that these objective factors alone cannot constitute a sporting succession. In the Panathinaikos versus Palmer case, our second legal authority, the panel stated that the rule of sporting succession was mainly implemented in order to avoid abuse and the circumvention of financial responsibilities. As a consequence of this being the main purpose behind the concept of sporting succession, cast held in the Moyersoen versus Procedural case, our third legal authority, that one can't conclude with a sporting succession alone based on appearances. In addition, the rule of sporting succession is placed in FIFA's disciplinary regulations, the FDC, meaning that failure to comply with a previous club's debt may result in sanctions. From this, it naturally follows that the rule was implemented in order to punish abusive or fraudulent behavior. Based on this, we submit that such fraudulent or abusive intent needs to be proven in order for the panel to deem our client ETA SC 2020 the sporting successor. To hold otherwise would be to apply the rule broader than its intended purpose. At this point, I would also like to remind the panel that the applicable standard of proof in disciplinary cases such as this one is comfortable satisfaction. This derives from the FTC Article 35, subparagraph 3, and consistent cast jurisprudence. One of these cast cases, the Dirk de Ridder case, our fourth legal authority, states the standard of proof, therefore, is set higher than a balance of probabilities, yet lower than proof beyond reasonable doubt. Pursuant to Article 36, subparagraph 1, the respondent, or the burden for proving this, rests on the respondent. There is nothing in the uncontested facts or the procedural clarifications that can leave the panel comfortably satisfied that ETA SC 2020 was set up with abusive intent and with the primary purpose of circumventing ETA FC 1997's financial obligations. In fact, the only evidence clear to us, according to the procedural clarifications, point 30, is that ETA FC 1997 did face financial difficulties prior to their bankruptcy. Any evidentiary material is therefore merely circumstantial and cannot satisfy the applicable burden of proof. The absence of proof of any such abusive intent should therefore in itself be enough for the panel to conclude that ETA SC 2020 is not the sporting successor. And with that, I conclude our first submission to the panel. And unless the panel have any questions regarding this issue, we'll move on to the second argument.
Thank you very much. Now, you're saying that we should look at fraudulent behavior. Can you give us an example? I mean, how would we know whether there was fraudulent behavior on the part of one of the parties? What is it that we need to look for?
The proof of fraud, thank you for the question. The proof of fraud is a delicate question. And when talking about fraudulent or abusive intent in a situation like this, it is that of, to put in a quote, clear the balance sheets. And that means by selling off, for example, a club with high debts, but then establishing a new club designed to look exactly like it, but without the debts, one may look at a situation where there could be fraudulent or abusive intent.
So if I can resume, what you're saying is if the transaction was not at arm's length, that would be an indication for fraud. Would that summarize your position?
Such a transaction could indicate, but could not satisfy the applicable standard of proof in disciplinary cases such as this one. That's our position.
talking about the standard of proof and the evidence that is necessary, we just said what would be necessary. He said there's hardly any evidence, and if there is something, it's mainly circumstantial. Now, given the timeline of the different actions that happened before the selling out of some of the assets, the registration of the ETA FC, creation of a new club, knowing that the main shareholders was the same person, could you say that there is a clear presumption that there could have been knowledge, fraud, or the objective to circumvent or to not pay what was owed or due at that point? And given that fraud normally is intended to be not discovered, this circumstantial evidence, how the facts developed, would be of higher weight than in other cases.
Respectfully, I would disagree. There cannot be a presumption that a person, a legal entity, has acted with fraudulent or abusive intent. The burden for proving such abusive or fraudulent intent must rest on the party alleging such. Yes, that is our position.
Thank you. I think that you can follow on the next point, please.
Should the panel find that sporting succession doesn't require subjective intent and decide to apply a more objective approach to the question, our position is still that the objective elements present are anyway insufficient to deem ETA SC 2020 the sporting successor of FC. This is issue 1B of our skeleton. The FTC Article 15, subparagraph 4, as I mentioned, presents non-exhaustively the relevant criteria in the assessment. This includes the headquarters, name, legal form, team colours, players, shareholders, or stakeholders ownership, and the category of competition concerned. However, other elements may be fully relevant. This is because the bottom line question for the panel to decide on, according to the Bergen versus Suska Sofia case, our fifth legal authority, whether the new club gives, and I quote, an image of continuity to the eyes of the general public. ETA SC 2020 does not give an image of continuity to the eyes of the general public from that of ETA FC. And for the next few minutes, I will demonstrate why. In the assessment, the panel must keep in mind that the rule exists as a narrow exception from the principle of agreements only binding inter partes. According to Haas, in the Benjamin van den Broek case against FIFA, our sixth legal authority, and I quote, the concept of sporting succession should be applied very carefully and only in a restrictive way. These are strong words from Haas that indicate a high threshold for applying the exception. With that in mind, I now move on to the assessment. First of all, although the club's names bear certain similarities, the use of the creation date in ETA FC 1997 and ETA SC 2020 distinguishes the two clubs from each other. The judge's reasoning in point 24 of the challenge decision is therefore wrong, where it held that the nominal creation dates are irrelevant. In fact, our client, by using 2020, showed to the public that the club is recently established and not connected with the old ETA FC 1997. The DC decision is also wrong when in point 24 states that ETA SC 2020 leaves an impression of adopting the old club's history. According to the uncontested facts, paragraph 19, ETA SC 2020 does not hold any reference or lay claim to ETA 1997's achievements. By not doing so, ETA 2020 clearly dissociates itself from the previous ETA's legacy and does not adopt its history in any way. In the aforementioned Palmer case, the panel stated that this, reference to a previous club's history, is an important element in this assessment. The panel should therefore attach the same weight in determining whether ETA SC gives an image of continuity in the eyes of the general public in this case. Another relevant criterion pursuant to Haas jurisprudence, and presumably something the respondent would argue, is the similarity of logos. I asked the panel, or I direct the panel's attention to Exhibit 3 and 4, where the logos are displayed. If you look at the top, you can see that both ETA SC 2020 and ETA FC 1997's logos are separately trademarked. Thus, the competent trademarking authorities of AFLOS have deemed the two logos to be sufficiently different from one another. Seeing as Athenian law governs the two clubs at a national level, CAS should deem the legal authority applicable pursuant to Article 58 of the CAS Code, and therefore respect this decision. As a consequence of this, the logo cannot indicate an image of continuity. In this Discuss Sophia case I mentioned earlier, CAS concluded with a sporting succession, partly because the new club used the same logo and laid claim to its predecessors' history. As shown, these elements are, however, absent in our case. CAS jurisprudence also shows that whereas similar cases should be treated similarly, dissimilar cases should be treated differently. The result should therefore be different here. Furthermore, none of ETA SC's top management, board of directors, shareholders, or majority of coaching staff are the same as ETA 1997's. The challenge decision is wrong when it in point 24 disregards this fact. In fact, CAS jurisprudence shows the polar opposite. In the Shabab versus Shanghai Football Club case, our sixth legal authority, 5 out of 6 people from coaching and management stayed the same. CAS deemed this indicative of a succession. And in the aforementioned Palmer case, CAS deemed it an important element against succession that none of the same board members were involved in both clubs. It should therefore not only be a relevant element in the assessment, it should be an important element against succession that none of the influential positions in ETA 2020 are filled with the same people in that of ETA FC.
Just one question. Could you tell us a little bit more about the ownership of the new club? First, and second, what about the ranking of the club? Could you explain how and why the new club asked for getting the possibility to start the competition at the same ranking as the former one?
First of all, we do not dispute that the ownership is a relevant criteria in the assessment. However, because of 2 reasons, the panel should not give this criterion a lot of weight. The first reason is that in the objective test, the main question is the public's perception. So does the club give an image of continuity from the old? And the ownership is not a distinguishing element of that of a club to the public. Therefore, the same ownership does not indicate to the public that it is the same club. And secondly, I would like to draw the panel's attention to the procedural clarifications point 5 and 7. According to point 5, Mr. Tripper only appoints the board members of the company he himself directly owns. He does therefore not directly appoint the board members or the important people in ETA SC 2020. And according to the procedural clarifications point 7, he has not had anything to do with the choice of logo and presumably none of the other elements the new club chooses to display. This is because the board members of ETA SC 2020 make this decision. Because of these 2 reasons, the ownership criteria should not be given a lot of weight in the sporting succession.
Coming back to the logo, you just said the logo is not the same, or before you said the logo is not the same. Couldn't it be argued that the logo, the new logo, is just an evolution of the former logo, like a modern form, that it didn't have to take the same form, but want to be more modern, give a modern look to the logo?
Thank you for your question. I understand your position. However, as I argued, they are separately trademarked, meaning that the competent authorities have done a concrete assessment of the 2 logos and decided that the new logo does not infringe on the trademarked rights of the old club's logo. That is reason 1. And secondly, I would like to point out several differences between the 2 logos. So first of all, the old logo consists of 1 triangle. The new club's logo exists of 3 triangles. In addition, the shade of blue is different. And thirdly, the club's name is now placed underneath the logo. Because of these reasons, the logo still don't indicate an image of continuity. And yes, sorry, your second question was to do with the succession and competition. Our position is that ETA SC 2020 merely used a legal fast-track procedure that is recognized in ATHLOS. They did therefore not display any abuse of intent of the kind by utilizing the assets they purchased through the IPR asset transfer and decided to use a fast-track procedure to compete in the same competition. Thank you.
Thank you.
So, to summarize, ETA SC 2020 has changed its logo, name, the majority of staff, and created a new website and social media which does not refer to the achievements of ETA 1997. The club therefore gives no image of continuity to the general public from ETA FC. So in light of the objective criteria as set forth in Article 15, subparagraph 4, it should be clear to the panel that the appellant is not the sporting successor. And that I conclude our second submission. And if there aren't any questions, I'll give the word over to my colleague.
I think you can follow up. No question, no more questions.
Can you hear me well? Okay. Dear President and honorable members of the panel, I am going to address the remaining issues, and I will be starting with our client's right to be heard. The right to be heard is a fundamental procedural rule recognized by Haas in jurisprudence, for example, in the Croatian Golf Federation versus European Golf Federation case. This is our legal authority number 9. According to the uncontested facts, point 24, ETA SC 2020 was deprived of the right to contest the substance of the debt now opposed on them. The right is also guaranteed by the ECHR Article 6, our legal authority number 10, and in the Walston versus Norway case, our legal authority number 11, a breach of this right to be heard was per se enough to set aside the decision. As Switzerland is a party to the ECHR, the panel should deem its jurisprudence as an applicable legal authority pursuant to the cost code R58. By the same logic, a decision in which ETA SC's right to be heard has been disregarded, it should per se be enough to deem them non-liable. Holding otherwise would jeopardize the fundamental procedural right. I will now move on to bullet point 2B in our skeleton. From the case preparation, we know that the respondent will allege that the violation of our client's right to be heard can be repaired by a de novo hearing. We contest this, The power to review a matter de novo derives from Article R57 of the CAS Code. The article stipulates that a CAS panel may review the facts in the law, and I now quote, issue a new decision which replaces the decision challenged. Pursuant to the wording of R57, and according to a number of CAS cases, including Radoux versus FIFA, our legal authority number 12, the competency of CAS is limited to the subject of appeal. Consequently, the statutory legal basis for the appeal defines what the panel has competency to review. In the appeal DC decision, the judge was to decide on ETA 2020's liability for the debt adjudicated against ETA 1997 in the DRC decision. DC did not have the competency to determine the actual existence of the debt. The subject of appeal therefore excludes the question of the debt's existence. Consequently, the panel cannot review the underlying issue where a client's right to be heard was violated. Thereby, CAS does not have the competency to cure the violation of the right to be heard. Finally, any claim raised by the respondent that our client's right to challenge the violation that has been waived, I'm going to rephrase that. Any claim raised by the respondent that our client's right to challenge the violation has been waived must be rejected by the panel. Jurisprudence from the ECHR, for instance, in Pfeiffer and Planck versus Austria, our legal authority number 13, the ECHR accepts that the right to be heard can be waived, but only if the waiver, and I now quote, is established in an unequivocal manner, end quote. In addition, the actions behind such a waiver must correspond to the severity of its importance. In our case, a waiver effectively means that our client has to accept a debt it was never allowed to challenge. Consequently, the panel must set a high threshold for accepting a waiver. Furthermore, the only argument for such a waiver is the fact that ETA SC 2020 did not bring up the issue in the previous proceedings. This mere implicit indication can in no way satisfy the panel that our client unequivocally gave up the right to be heard on such an important issue. If the panel doesn't have any questions regarding the right to be heard, I will move on to the issue regarding due diligence.
I think we have a question, please.
So your position is that right to be heard was violated, or in the first instance, because you never had a chance to challenge actually the debt. And you say that at the CAS level, we're in the same matter of dispute, and therefore there is no way CAS can remedy it. But what would be the consequence? So you request us to squash the previous decision because of a violation of the right to be heard. And what would happen next? Would the case be sent back to which organ actually that would be competent to look at the debt?
If I understand your question correctly, our position is that the debt cannot be imposed on our client.
So that would be rather a substantive issue than a right to be heard issue. Is that correct? Because you pleaded on right to be heard. That's the only question I have. If we follow your request and say we squash the disciplinary decision because there was a violation to be heard, how would that all end up? I mean, would we have to go to the DRC? Would we have to go to the DC? Which would be the competent organ to look at?
It would be the DRC.
The DRC.
And on the same line, did you consider any time to sue and to have Mrs. Nikki in these proceedings? Then to get the possibility to be heard and on her claim?
We have not invited Ms. Nikki here, no.
Did you consider it as impossible, or did you?
The issue to be resolved.
It was not relevant.
Thank you. We did not invite Ms. Nikki or consult with her because this is a matter of the disciplinary sanctions of our client and not a matter of whether or not the debt exists. Thank you.
Please.
Yes, well, I'll go as well then. You said it cannot be implicitly deferred from the decision that your right to be heard was not violated, but shouldn't you have raised the violation of the right to be heard, for instance, in front of the DC to be able to raise it now?
That is one of the arguments I just went through, that it might be, to be transparent, it's not stupid, sorry for the language, to do that. However, we haven't lost, or our client hasn't lost the right to raise the issue in light of the ECHR jurisprudence. It's too high of a threshold.
And did you think about eventually attacking the DRC decision once you got the knowledge of the fact that it existed, or that you were now being held liable as a successor, or potentially liable as a successor?
Apologies, I didn't quite understand your question.
Once you got to know of the existence of the DRC decision, knowing that you had not been heard, knowing that now you would eventually be held liable as a successor of the FC, would you have considered appealing that decision or attacking that first instance DRC decision? And if not, why not?
If I can confer with my co-counsel, if that's okay.
Of course.
Since the premise is for these issues is that we are not, no, that we are supporting, sorry. To appeal the decision before we were deemed the sporting successor would be an admission of being the successor. That's our position.
Fair enough.
Thank you. You can, hold on. Be aware about the timing, please.
How long? Okay. I'm going to move on to the third issue in our skeleton and on why Ms. Nikki has not displayed the requisite due diligence. As stated by Haas in the Rangers case and confirmed in the Vijovic case, our legal authorities number 14 and 15, a degree of due diligence does exist as a prerequisite for considering a new club non-compliant in terms of the FTC Article 15. According to Haas in the Tartar Tomeki case, this means that a creditor must be vigilant and take prompt legal actions towards retrieving their claim. The duty to act arises from the moment there is a feasible theoretical possibility that the claim could have been recovered through the national legal system. The expression theoretical shows that a mere hypothetical possibility for a positive outcome is sufficient. As illustrated by the Bergen versus Sophia case, only if the national legal system prohibits a full recovery of the credit, it is not feasible theoretical. In our case, Ms. Nikki didn't appeal the Athlean bankruptcy decision, even though she, according to Exhibit 5, had 60 days to do so. These 60 days shows that an appeal was feasible. Furthermore, according to the uncontested facts, point 24, there generally is a 5% statistical success rate of an appeal against the Athlean bankruptcy decision. In this regard, it's important for the panel to note that according to the procedural order, point 16, the court recognized that she, Ms. Nikki, in principle, was owed the entirety of the claim debt and that her credit was privileged. Consequently, there was a feasible theoretical possibility for her to retrieve her claim. This means, as mentioned, that Ms. Nikki had a duty to take prompt and vigilant action. However, she remained passive. As in the Vijovic case, a passive stance can be excusable, but that's only if the creditor didn't know about the possibility of recovery. According to the uncontested facts, Ms. Nikki knew. Furthermore, several other creditors filed a joint appeal, and the only action required for Ms. Nikki to join this appeal was to instruct her lawyer. The actual labor involved was, in other words, the bare minimum. Based on this, Ms. Nikki has failed to take prompt and vigilant legal action despite the feasible theoretical chance of success. She has therefore lost the right to the claim. If the panel doesn't have any questions regarding this issue, I'll move on to the last. Thank you. The last issue is whether that Ms. Nikki couldn't claim her debt before FIFA because it was a case of res judicata. The principle of res judicata means that an earlier and final decision is conclusive in subsequent proceedings regarding the same issue. According to Haas, in, for instance, the Christian Nasudi versus Athens case, 3 cumulative requirements must be fulfilled for the res judicata principle to apply. That's the first requirement is that it has to be an identical claim. Secondly, the same parties must be involved. And thirdly, the matter must be based on the same facts and evidence as the time of the first judgment. I kindly ask the panel here to bear in mind that the question is whether the DRC was wrong to handle the claim against ETA FC 1997. The 3 requirements, therefore, are fulfilled. Firstly, Ms. Nicky's claim was $150,000 in both the bankruptcy proceedings and in front of the DRC. Secondly, the facts and evidence taken into consideration in both instances was exclusively Ms. Nicky's right following her contract with ETA FC. Thirdly, both decisions were issued between ETA 1997 and Ms. Nicky. Consequently, the three cumulative requirements are fulfilled and the principle therefore applies. The DC decision was therefore wrong to enforce the DRC decision upon ETA SC 2020. If the panel doesn't have any further questions, I'm going to repeat our request for relief. On these grounds, sorry. Okay. On these grounds, we, on behalf of the appellant, ETA SC 2020, request that Haas, primarily in the first alternative, set aside and annul the challenge decision. Should the first alternative be rejected, we request that Haas revise the challenge decision so that all sanctions imposed on ETA SC for the breach of FDC Article 15 are set aside and left without effect. Thank you.
Thank you very much. So I give the floor to the respondent.
Thank you, Madam Arbitrator. Am I audible properly? Panel, in the present matter, ETA SC is indeed the sporting successor of ETA FC. The differences mentioned by the appellant were created just for the sake of showing that there exists a difference if in case a situation arises like the one we are in the present situation. And everything was conspired and executed, keeping all of it in mind. The council will be establishing this by presenting two lines of argument. First, that ETA SC fulfills the criteria provided under Article 15(4) of FDC 2019 for establishing succession. And second, that it fulfills the subjective criteria and there exists shady and fraudulent practice. Before delving into the arguments, the council would like to put forth that the principle of sporting succession, the main rationale behind the principle of sporting succession is to protect the creditor's right to recover its credit and promote financial justice. Moving ahead with the first limb of my argument, the council would be establishing that both the clubs are same in public perception because various elements are same in both the clubs. And the importance of public perception has been upheld in various CAS decisions, including CAS decision of 7092, cited as legal authority number 9 in our submissions, as well as in CAS decision 6831, cited as legal authority number 8 in our submissions. Panel, referring to question number 28 of the procedural order 1, 60% of fans of ETA SC answered to the poll that they would support ETA SC as if it were ETA FC. Therefore, it is an established fact that both the clubs were same in public perception. The council will be dealing with the similar elements one by one, starting with the first, that is the name, color, and logo. Panel, the first thing we mentioned today before the bench, before starting the hearing was our names. The primary reason is that name is something through which we are identified. And in the present case, if the panel may refer to para 16 of the SAM case, along with exhibit 3 and 4, which shows the logo of ETA SC and ETA FC, it can be inferred that the name as well as the logo and colors of both the club are same. Therefore, it can be established that ETA SC portrays itself to be same as ETA FC, and there is the intention to maintain and reflect the sporting history. Moving on to the second element, that is the players and administrative personnel.
Just one question about the perception, public perception. So if I understand correctly, you say that FIFA relies on the public perception. So actually the fan perception, does it mean that the fan are the one who are making the decision of a club being a sports sector or not? Is it the fan decision to
No, Madam
drive your position?
Thank you for the question, Madam Arbitrator. It is not the only criteria. It is an indicative criteria, and there are various other criteria which are fulfilled in the present case, due to which ETA SC is the sporting successor of ETA FC, which will be dealt by the council in the further submissions.
Yes, you just referred to what you just said before. The question was asked that ETA SC tries to refer to the sporting history of
Yes.
the ETA FC. Can we tell me why? Why the sporting history? So far, we've talked about perception of the people, the name. Why the sporting history?
Mr. Arbitrator, although the new club, that is ETA SC, didn't refer to these achievements on its website, but by purchasing the brand ETA and using the brand ETA in its name, they have in a way assumed the history of the old club. Therefore, in the present case, the council contends that the old club, that is the new club, that is ETA SC, has taken the history of the old club, that is ETA FC.
I would have also two questions. The first question is, you said the whole purpose of this rule, sporting succession, is to protect the creditor.
Yes.
Protect the creditor. What does this have to do with public perception? Wouldn't it be important what the perception of the creditor was? If you want to protect him, on what did the creditor rely? So what I want to know is, what is the link between public perception and protection of that specific creditor? That would be my first one. And the second question is, if I was a fan in a specific region and there was a club, it's only natural that I'm a fan of the club. If the club disappears, what other option do I have to be a fan of the next club that's going to be in that region? Therefore, my question is it actually a fair question to ask to the fan? Would you support the new club? I mean, what other choice does he have? He wants to see football in his region. Otherwise, you would have to travel hundreds of kilometers to see another game. So these would be my two questions to you.
A very pertinent observation, Mr. Arbitrator. Answering to your question, in the present case, it is not about the fans. The conclusion that we are trying to draw in the present case is that ETA SC, that is the new club, they could have make various other differences so that they could have not been called the successor of the old club. But in the present case, although the only differences they have made are on the face of it, they are not substantially different from the old club. This is what the council is trying to put forth in the present submissions, through the submissions.
The thing was that you said it's the appearance in the eyes of the fans that you laid so much, let's say, I know that was a strong argument of yours. And I question what it has to do actually with the creditor protection in that specific case.
Mr. Arbitrator, answering to that question, the purpose of the principle of sporting succession is to protect the creditor's right. And in the present case, since the old club has disappeared, it got disaffiliated, it got dissolved, and the new club came into being. Here comes into picture the principle of sporting succession. And in order to prove sporting succession, one of the very important elements is public perception. And that is the reason why we are dealing with public perception. Although the aim of the principle is to protect the creditor, but in order to in order to establish that the new club is the successor of the old club and it has to pay the debts due to the creditor, we need to establish that it is the successor of the old club. And in the present case, for establishing that it is the successor of the old club, we need to fulfill various elements. And one of those elements is public perception. Therefore, we are dealing with public perception in the present case.
Thank you very much.
I hope that answers your question. May I proceed with the submission?
Yes. Proceed, please.
Moving forward with the second element, that is of players and administrative personnel. If the panel may refer to para 15 of the SAM case, along with question number 14 and 15 of the procedural order 1, ETA SC had same players as well as administrative personnel, including secretaries, caretakers, and maintenance staff. Further, moving on to the third element, that is of stadium. Fans associate stadium to the identity of the club. And in the present case, referring to para 21 of the SAM case, ETA SC declared Arena Sportiva to be its home stadium, which was previously utilized by ETA FC. And the council would request the panel to give special consideration to question number 22 of the procedural order 1, which states that the lease contract of Arena Sportiva directly transferred to ETA SC and no new contract was signed between ETA SC and the municipality. It was transferred by the virtue of the same sale purchase agreement which was signed between ETA FC and Dinaria. This establishes a clear link between ETA SC and Dinaria. Moving further with the next element, that is the category of competition and transfer of federative rights. During the hiatus of liquidation of ETA FC and formation of the appellant, that is ETA SC, ETA SC requested to take place of ETA FC in the league, to take place of ETA FC in the league. And it was permitted to do so. This shows that sporting continuity has been maintained by the means of forming a new club, that is ETA SC, which was capable of replacing ETA FC in the same category of competition. Furthermore, the position of ETA SC now in the league shows that there took place the transfer of federative rights from ETA SC to ETA FC, and therefore this element has been fulfilled. Moving forward to the fifth element, that is of shareholder, stakeholder, management, and ownership. Panel, Mr. Roundtripper was the controlling stakeholder of ETA SC as he held 70% shares of ETA SC. Referring to question number 3, 4, and 5 of the procedural order 1, it can be inferred that Roundtripper indirectly owned 99% share of BV as well. Therefore, he was also the controlling stakeholder of BV. Now, referring to para 4 of the SAM case, as well as the above aforementioned arguments, it can be established that Mr. Roundtripper had control over BV, BV had control over Dinaria, and Dinaria purchased the trademark and other assets of ETA FC, after which ETA SC was established. This shows that this criteria has also been fulfilled. Therefore, keeping in mind with all of the above discussed criteria, we can come to the conclusion that the elements provided under Article 15(4) are met in the present case. Moving forward to the second limb of my argument, the council would establish that there was a clear intention of deceiving the creditor, as well as there existed shady practice on part of ETA SC. In the present case panel, referring to para 7 of the SAM case, it states that ETA SC communicated to Ms. Nikki that it was not in position to satisfy her request without giving a reason. Further, later on, no further communications were made to her in spite of her sending various follow-up letters. Further, on 18th July 2020, the negotiations between ETA SC and the President of Dinaria started for the sale and purchase of assets, and within 10 days, the sale purchase agreement was signed. On 5th of August, ETA FC disaffiliated and ETA SC filed for incorporation. Further, on 16th of August, ETA SC was established as a limited liability company, and on that very same day, it took place of ETA FC in the league. And all of these events took place within the very short period of 15 days. As also pointed out by the panel, that all these events took place in a very short period of time, and the chronology of events makes it self-evident that the creation of the new club, that is ETA SC, during the bankruptcy of ETA FC was set up to avoid the financial obligations that the old club had against Nikki. Thus, summing up what has been stated so far, the similarity among all the objective criteria and existence of shady practice very evidently establishes that ETA SC is the sporting successor of ETA FC and therefore should be held liable for the obligations that the old club had towards Nikki. Thank you. This was end of my submissions.
Good evening, members of the panel. I would be dealing with second, third, and fourth issues in the present case, which relates to right to be heard, due diligence on part of Ms. Nikki, and non-extinguishment of the debt in governing laws. Proceeding with the issue of right to be heard, the Council would substantiate its position into two limbs of arguments. Firstly, ETA SC had the opportunity to raise the issue of its right to be heard being violated in the subsequent DC decision, which it purposely chose not to do. Considering the restriction on the adjudicatory powers of FIFA DC, the conduct of appellant of not even raising the issue shall be considered into the question as they participated in the DC without contesting the jurisdiction or alleging the violation of its right to be heard, which is evident from para 31 of the SAM case. Moving forward, secondly, ETA SC still has the opportunity to raise its concerns related to right to be heard being violated in the present CAS decision, as CAS adjudicates the matter de novo in accordance with Article R57 of the CAS Code. Therefore, if the appellants believe that there are any procedural flaws in the present proceeding or any previous decisions, that would be cured in FIFA by the in CAS by the virtue of Article R57 of CAS Code. Moving further with the issue of due diligence, the Council of Respondent would establish that Ms. Nikki showed the requisite due diligence on her part in the entire proceeding while claiming her due. And for this, the Council would substantiate its position under four limbs of arguments. Firstly, it must be pertinently noted, panel, that under Athenian law, it is the responsibility of each creditor to obtain the knowledge of the insolvency and bankruptcy and file claims accordingly, as is mentioned under question number 27 of the procedural order number 1. Ms. Nikki, in the present case, even after having language barrier, entailment of extra legal cost on her, and being from a different nationality altogether, she was diligent enough to file her claims in bankruptcy. Moreover, panel, there was no theoretical possibility for recovery of claims had Ms. Nikki went into appeal of the first instance bankruptcy decision, and why the Council says so would be substantiated in the further submissions. The final decision in the appeal of bankruptcy court would also be based on the asset liquidation of ETA FC. Panel, through SAM case, we know that ETA SC does not have enough funds left to pay Ms. Nikki, as all of his assets are sold off. Thus, even if we consider that this case is an exception to the general cases of insolvency, as mentioned in question number 18 of procedural order number 1, the prospective amount would not be enough to pay every creditor or even all privileged creditors in full. Thus, there is no theoretical possibility that Ms. Nikki could have recovered her claim through the appeal of the first instance bankruptcy decision. Thirdly, panel, it is pertinent to note that jurisdiction of the bankruptcy court is limited to bankruptcy and Misnicki being the creditor of the club, the bankrupt club. The present dispute calls for establishment of sporting successor and other sports-related rights and liabilities which falls beyond the jurisdiction of bankruptcy court. Thus, FIFA being a specialized regulatory and adjudicatory body in the present case had the power to decide the present dispute. Moreover, panel, it is pertinent to note that FIFA rules and regulations does not require players to file their claims in bankruptcy as a precondition to have their decision issued in FIFA. Fourthly, panel, even if we consider for the sake of argumentation that Misnicki was not diligent, pertinent observation must be given to CAS decision of 6462, cited as legal authority 7 of our submissions, where it is decided that required degree of due diligence cannot be used as a blanket rule. An assessment of creditor's diligence has to be made on specific circumstances of the case. Although we do acknowledge the fact that it has to be a minimum degree of diligence, which through the previous submissions of the respondent, we have proved that in the present case, Misnicki performed the required degree of diligence, even if it was not mandated by FIFA statutes and regulations. Nothing in the file suggests that she remained passive and uninterested in pursuing her claims. From the day she was entitled to the claims, she made consistent and persistent effort to claim it from ETA FC, bankruptcy court, and later at FIFA. Thus, due to lack of appeal, questions should not be raised on her due diligence, as she was clearly diligent enough in pursuing her claims.
Yeah, I have a question for FIFA. It's Mrs. Nikki lodged a claim before the disciplinary committee. Did you ever consider, as FIFA, for having Mrs. Nikki in these proceedings as a party? And if not, why?
Well, can I discuss it with my... If I may answer that question. In the present case, Madam Arbitrator, the appellants were the ones who appealed the decision of FIFA DC. So they were in a position to make Misnicki or not make Misnicki a party. However, in the present dispute, since it's a disciplinary dispute, it is not mandatory for the players to be made a compulsory party in the present dispute, if that answers your question.
Thank you.
I would have two questions. The first one is, how can you say that Misnicki acted diligently without having the possibility of her statement or her witness testimony in these proceedings? So it goes a little bit along the lines that we just heard. It's your statement that she acted diligently. How would you know without her being present in these proceedings? And the second issue, we know that Misnicki chose the country where she wanted to play. We know that Misnicki chose also the club that she wanted to play with. She chose also the legal framework within this club is going to act. And now she's telling us that it's too burdensome to comply with the regulatory duties according to whatever she has chosen. I mean, it was a deliberate free choice of her. Why would that be burdensome? I mean, you said there was little chance of success. So if the chance of success would be 10%, would you change your mind? Whether it's 8%, would that make any difference? Is it 15 or 20%? What are you looking for if you ask for a diligent player?
Answering the first question of Mr. Arbitrator. Mr. Arbitrator, from the uncontested fact of the present case, we know that Ms. Nikki made consistent and persistent efforts in pursuing her claims, and that is evident from para number 8, 6, 17, 23, and 26 of the uncontested facts. Moreover, towards the second part of the question, in the present case, we are not contending that it was not Miss Nikki who chose the country or the club, but even after having the language barrier, the country that she chose to play in, the laws that she had to comply with, she complied with the requisite due diligence because she did go into the bankruptcy proceeding and filed her claims for bankruptcy. And it was only when she knew that there is no theoretical possibility that she would obtain her entire claim in full from the bankruptcy court, then she moved to FIFA as a member of FIFA, being the player in one of the football clubs.
Thank you very much.
I have a question as well. Concerning this non-feasible theoretical possibility. So if FIFA considers that it is established there was no possibility to get any money, the bankruptcy procedure, where would the money that Ms. Nikki asks from ETA FC, first case, basically, come from in case of decision of the FIFA condemning ETA FC to pay the money? Where does this money come from?
Thank you very much for your question, Mr. Arbitrator. In the present case, Mr. Arbitrator, ETA SC is the sporting successor of ETA FC. Now, being the sporting successor, they have the obligation to comply with the decision rendered against ETA FC. And thus the money, since ETA SC is in a financial capability to render the money to Ms. Nikki, in the present case, ETA SC thus would be paying the money. So their money would come from to be paid to Ms. Nikki.
But then there is a question. Do you think that ETA SC would be allowed to ask for the money back from ETA FC liquidation?
Madam Arbitrator, in the present case, ETA FC has been dissolved and it doesn't exist anymore. So they cannot ask. And since you are the sporting successor, you are the same club. So you cannot ask your own self to give yourself money.
But so ETA SC lost totally any possibility to recover this money from the previous club. Is that what you mean?
Indeed, Madam Arbitrator, because when you are the successor, you do get the rights as well as liabilities of the previous club. Moving forward with the issue of extinguishment of debt, Council would substantiate its position through three limbs of arguments. Firstly, for the sake of clarity, the governing laws in the present case would be FIFA statutes and regulations. And why the Council says so is that present dispute, as already substantiated by the appellants in the previous submissions, the present dispute calls for determination of sporting succession and other sports-related rights and liabilities, which falls beyond the jurisdiction of bankruptcy court. And thus, in the present case, FIFA statutes and regulations would take the front seat. Secondly, Ms. Nikki's debt is still pending against ETA SC, as the issue of sporting succession was not dealt before. The very reason of the reduced payment of Ms. Nikki has ceased to exist as by the virtue of existence of ETA SC as this sporting successor, as it is financially capable to render Ms. Nikki her due. Thirdly, panel, while imparting financial justice, Ms. Nikki's right of claiming the unpaid credit in full is to be considered as the above non-payment would be against the essential principle of lex sportiva. Moreover, the Council would like to submit that if decided otherwise, this would not only be detrimental to the interest of Ms. Nikki, but several other players who in future would fight for their rights, and their decisions would be based on the decisions of so-called lex sportiva established by these cases. And moreover, on the point of res judicata, as pointed out by the appellants, the present case, the Council pleads that the present case does not attract the provisions of res judicata, as the triple identity check has not been met in the present case. As for that to meet, there has to be same party, same object, and same cause. Panel, in the present case, the parties are two different legal entities. Although they are sporting successor, they are two different legal entities. Moreover, the object of the previous decision is substantially different from this proceeding, and same goes with the cause. Therefore, and reliance is placed on cast decision of 7543, cited as LA3 of our submissions, legal authority 3 of our submission, to substantiate that. Thus, the Council would like to conclude their arguments by saying that panel, bankruptcy is like dying. It is an event that risks with a stroke of sponge erasing histories that are at times hundreds of years old. It erases the history, taking away the brands, titles, traditions, important reservoirs of fans and passion. Indeed, the Phoenix Club comes into existence to retain the bankrupt club. It is submitted that FIFA would never inflict any unfavorable harm to any legitimate entity, but it would always ensure that activities of the Phoenix Club is not detrimental to the interest of any member of the football family. In the present case, the conduct of ETA SC, the appellants, have been detrimental to the towards Ms. Nikki being the player. Therefore, substantial consideration must be given to the arguments put forth by the respondent, and we pray that FIFA DC decision is upheld in entirety. Thank you. This was the end of my submissions.
More question? Yeah, okay. So you have, say, 1 minute or 2 minutes? 2 minutes for your rebuttal. Up to you. Decide.
Thank you, Madam Arbitrator. As we have just heard, the appellant relies heavily on the proof of fraudulent or abusive intentions in order to conclude that there was a sporting succession. The panel, in this case, cannot be comfortably satisfied that this is the case because of 2 reasons. Firstly, according to the uncontested facts, paragraph 13, as I mentioned earlier, ETA FC had financial difficulties before the bankruptcy proceedings. And secondly, according to the procedural clarifications, point 11, prior to the bankruptcy proceedings and when they were undergoing financial difficulties, ETA FC tried to escape these economic difficulties by selling their tangible and intangible assets in order to gain capital and pay off the capital they owned. Therefore, ETA FC has not acted in a way that indicates that ETA SC and ETA FC have communicated and there is fraudulent and abusive intent. I give the word over to my colleague.
The opposing counsel claims that Ms. Nikki has been diligent simply by claiming her money in the bankruptcy proceedings. And I just want to remind the panel that this is a question of whether it was a feasible and theoretical possibility of whether she could retrieve her claim, which we have proven that there was. Thank you.
You have the floor.
Yes. Madam Arbitrator, as mentioned by the appellant regarding the standard of proof, although there is no conclusive proof and the respondent agrees to that, but it appears from the facts very evidently that there existed the fraudulent practice on part of ETA SC, as it did various activities as already established by the respondents in their arguments, that within the 15 days, a lot of events took place, which very evidently established that there was a fraudulent practice which took place due to in order to avoid the financial responsibilities on the part of ETA FC. That would be it. Thank you.
Question. Thank you very much. It was very interesting. I think that it shows that you were very well prepared. I am very impressed by the preparation, and I think my dear colleagues share this view on not only the preparation, the knowledge of the case, of course, and also persuasion. I'm sure it will be a difficult task for us. But first, before closing this hearing, I would like to ask you if you are satisfied on the way it has been held. First, appellant.
Madam Arbitrator, no objections from the appellant. Thank you.
Thank you. The respondent?
No objections, we confirm.
Thank you very much. So have a nice day. I think that we will take our time. I think that first there is a conference, and after the conference, we will give you the outcome of this fantastic hearing. Thank you very much for all, and thank you for the team too, who were attending and pushing your oralist. Thank you very much, everybody.